family dispute, and if you have a dispute about the property, or you bought a property and there is an issue with the seller, or you go to the court again. If you are not able to resolve the issue, you go to the court. Or if you are in a government employment, you don't get an increment, or you think that you are eligible for a promotion, but you are not able to get it, then again you go to the court. So, court is a place where the laws are interpreted, and orders are made, and all the decisions are made, and so on. So, likewise, the law and the enforcement of law touches all walks of life, whether you like it or not. It touches. For example, even if you don't engage with a lawyer or engage with court system or so, still law touches all aspects of your life. For example, if you buy a motorbike or a car, you pay taxes like a GST, and for GST there is a law is there. Even though you don't go to the court, someone, the seller, have to pay GST based upon GST laws, and the vehicle is designed as per the requirement under Motor Vehicles Act. Even though you don't actually know the law, everything was organized around the law which is related to motor vehicle and the law related to insurance. Likewise, even with if you drive a car in a highway, there is an act called Highways Act. Like even if you um, uh, climb in like in your apartment, you might have a lift. For that, there is an act called Lift Act. So likewise, for everything, there is a law. Whether you know it or not, that is how the government and our systems are regulated, whether you like it or not. But at the same time, the question is then, uh, why should I know law? The important thing is, law says that ignorance of law is not an excuse. You cannot say that I don't know the law, so that is why I did it. So you can't escape that. So the moment the law is published in the Gazette, the Gazette is the government official newspaper published, the assumption is everyone knows the law, should be knowing the law. So you can't plead or take an argument that I don't know about the law. Like for example, if you are going to construct a building, there is building construction rules for the particular state is there. How much setback should be in the front and how much setback should be in the behind, all the building code and all these are laws. You can't say that I don't know the law. If you violate the building code, then the municipality will come and demolish the wall or the particular structure, so on. So why you wanted to know the law? Because ignorance of law is not an excuse. Which means whether everyone should know the law. You're supposed to know the law as per like on a theoretical framework, but at least you should be knowing when issue comes up, whom to approach, what are the institutions available, uh, and what are the some overview like what do you do and everything. You should be knowing. So the first question is when you ask is what is law actually? When you when you come to the question of what is law, there are many theoretical answers are there, and there is many theories also there. But practically, for a lawyer or for a common man, what is law is one, the Constitution of India is the law, and the law which is made by the Parliament or the state legislature is a law, or the rules made by the government of either state government or central government and published in the Gazette is the law, or certain kinds of GOs, government orders, or government regulation, which is published in the Gazette is law. So why this is so important is we in a casual conversation say that, oh, this is the law, that is the law. So you should know that, for example, if for violation of not wearing helmet, they will charge you with fine. Then you should ask, you should be knowing under what rules and regulation they are imposing the fine. They can't just make a fine, but we don't care much about what section and what we need to offer. For everything, there is a reference point. So if someone says that there is a law, something, for example, there is a law in Chennai that you should not take bath, like bathe in the public places. And if I say it, look very funny, but where it is, there is a law which is called Chennai City Police Act. Likewise, for everything there is a reference. For example, even in Madras High Court, now the new rule is came, like earlier the newspaper, earlier all the papers which we file in the court will be legal size, green size. Now there is a new rule came, say that it should be A4 size. So where it is, it's not like court just can say something like anything. There is a rule, criminal rules of practice, and a particular section says that the paper should be A4. So for everything, when we say law, everything there is a reference point. So if you in the course of conversation, if someone says that, oh, this is a law, then you should ask which section or which rule or which GO. This is very important for any conversation. Then why this is important for a common man or as a church leaders or one minute. Church leaders or a common man is the order of the supremacy of law is like constitution is supreme, then the acts law made by the parliament or state government is supreme. The second order. Then third one is the rules made by the government, and then the last one, the government orders made. Why this order is important is sometimes suddenly if a government person GO saying that this and these things cannot be done, then we should be in a position to see, or your lawyer, or if you are interested, you can read always in the law to see that whether it violates the Constitution of India. For example, if you are running a Christian school, suddenly a GO comes in saying that hereafter the school will be managed and administered by the government, and government is taking a direct control. It is a law, and it is a law which is passed by the government or a secretary of the government based upon some statute. If you know the Constitution, then you can say always challenge that in the High Court or Supreme Court, saying that try to administer and manage minority institution is a fundamental right. So this GO violates or government rules violates the constitution for constitutional right which is given in the Constitution. So quash it or make it unmake the law. So likewise, as church leaders, when you have a discussion, that all this will help. So for that understanding, only I'm just emphasizing on what is law. Then let us come back to the second scenario. Now this we talked about what is law and everything. As an ordinary citizen, like as I mentioned earlier, when you come to courts, when you engage with the court, and what is the process? For example, there are two types of engagement, like proceeding. One is civil procedures and criminal procedure. Criminal laws are administered through criminal procedure, and civil laws are administered through civil procedure. Um, when I come to criminal law, I give a practical example. Like for example, you one day you this moment. One day you went out, and when you came back to home, you saw that your house is break open and all the valuables are stolen, and you naturally give a complaint to the police, and the police will file a first information report. Then they'll proceed to the spot, and they will inspect the spot. Then they will interview the people who witnesses or the people who are in the surrounding, and take down the statement, collect the samples, fingerprints, and they sometimes bring the sniffer dog, And with all that, they try to find. Investigation is actually goal is two. One is to find out the truth and to collect evidence. So finally, the police will find out after investigation and track all the phone calls during the time in that area. Finally, they narrow down to someone and they interrogate that person, and finally he confessed, or they come to a conclusion that this guy did it, and finally they recovered the stolen property, and then the police, with all this, will produce before the magistrate. With that, investigation is over. Still, you are not able to get your. The police found that, but found all the ornaments. That doesn't mean that by default you immediately can go and collect it. Then there is a process. Then you have to engage with the lawyer. Then lawyer have to file an application in the court saying that this property is my property. Then they'll inquire you. Then you have to identify the property on oath. Then they will return you all the property. But whether the as far as you is concerned, the issue stopped with you got the money, you got the stolen property, money and everything, you came back. But the criminal process doesn't stop there. Once the police file the final investigation report, um, the with the magistrate is the lowest criminal court, and actually that is the entry level court. So all the investigation papers will be filed. FIR will be after police filing FIR, the FIR copy will be sent to the magistrate. All the papers, investigation papers, will be sent to the police. The police will send to the magistrate. Magistrate is the entry level court. Then magistrate then will decide based upon the investigation report which is filed, our final report they file, will decide whether there is a ground to take up the case. Ground, like whether there is solid evidence or something to take up the case. If not, the government, the magistrate in the threshold level itself will dismiss it. Generally, they don't do it, but they'll take it up. They can, but they'll take it up. Later, the magistrate looking at the after the charge sheet or the final investigation report will come to conclusion that what kind of offense is made of. If it is punishable less than 3 years, he himself will conduct the trial. I will explain what trial means. And if it is a punishable above 3 years to 7 years, he will send to the assistant sessions court. There is a superior court above it for trial. If it is above 7 years, then it goes to the sessions court. That is the final trial court. Before going to that trial procedure, I want to explain the difference between trial court and appellate court. Trial court is a place where they decide the facts, like whether he actually killed this man or not. The appellate court's role is to verify the correctness of that judgment of the lower court. So appeal court will not hear evidence only in a rare and exceptional case. Whether what happened, what is the factual situation on the ground, whether it is an accidental death, whether it's a murder, or it's a natural death, all will be decided at the trial court based upon the evidence. The evidence will be given by way of giving like person coming into the witness box and giving chief examination. Like chief examination, the place where he himself volunteer and tell the story. And a cross examination, the opposite counsel will test your truthfulness by putting cross examination. Evidence means his testimony. Then if there is a documents to prove something like medical report or something like postmortem report, so those are documentary evidence. The third one is like a material object, like a knife or gun and everything. Through all this only, the which is presented before the court only, judge will come to a conclusion. Judge cannot travel beyond what is not presented before him. He can read 101 stories in the newspaper, he can hear a debate in the court, debate in the TV, but judge cannot travel beyond what is given before him. That is the evidence. Like someone have to come to the witness box and see the evidence. Someone have to produce the material evidence or object before the court or a document. Once that is a difference. The trial court will determine the facts, and the superior court will uh, is a place where they they find out the correctness of the decisions which is made in the lower court. So that is a difference. So after the trial court, after the evidence first will be presented by the police. Police's evidence will be presented through the public prosecutor or a prosecutor. And in a criminal court, the victim have no role other than coming as a witness in the court and tell the story. And that is the challenge, because the the case will be controlled by the public prosecutor, who is the police's prosecutor, and he will decide who will be coming to the court and who will going to testify in the court. So victim, and that is why sometimes if you have a corrupt or inefficient public prosecutor or a police, even if you're a victim, you won't get justice. So that is the reason why you want to have a fair, efficient public prosecutors. You have to pray for that. Then for the accused, he will have a his own lawyer, private lawyer, not the government lawyer. So after the prosecutor present his evidence, then after that, through victims and other documents and other things, then that will be cross-examined. Then after that, the judge will ask the accused. The process is before the judge start the trial, based upon the evidence presented before the judge by the police, judge will frame charges. See that you are accused of murder under section 302, and it is punishable by death, and because according to the police, you did this. Do you plead guilty or not? Generally, for bigger offenses, they'll say not guilty. If it is a small offense, like a traffic offense or punishable by 1 year or 6 months, they will just plead guilty and just pay the fine and move on. But serious offenses like murder, generally they will not. If they plead guilty, there is no trial, it will stop there. Usually they not plead guilty, then the trial starts. Then after the prosecution presented the evidence, the judge will, again, based upon the examination of witness, the judge will ask the accused, hey, these are the evidences presented against you. Do you have anything to say? Then he will have an opportunity to speak with the court. Generally, the accused will say that all these are false cases, I have nothing to do. But they have an opportunity to speak to the court. Then the judge will ask him, do you have any evidence to present on your behalf that all the allegations of the prosecutor are wrong? Then generally they don't do it, but sometimes they do have, and they will present their side of the story. Then finally they will have an argument, oral and written. Then the judge will pronounce judgment. This is the process in trial court. If he was sentenced, if he is convicted and sentenced to a jail time, if it is a smaller offense punishable within 3 years, then he can apply for suspension of sentence until he goes for appeal. Then the appeal goes. In the appeal, they look at how the lower court decision come to a conclusion. It is a tenable, whether it is correct in the law or so. If the judge finds that the lower court judge's finding is incorrect based upon the settled legal principle, then he will give an acquittal or dismiss the case. So this is how the criminal court goes on. Again, this is the process, and you will not be involved in all these things. Again, as a layman, what is my role? And what would be my challenge? For example, if you on 1 minute, in an online fraud, you lost 1 lakh rupees or 50,000 rupees. You go to the police station and give a complaint. Police, sometimes some policemen will be okay, give a receipt. Sometimes they say sorry, they give some excuse. No, it will not come here. This jurisdiction, your house is there. go to that police station, this police station, or sometimes they don't do anything. And if you're lucky enough, they will file an FIR. But rarely it happens unless it's a major offense like violence, murder, rape, or serious offense. Generally, without that, they will not file an FIR. Because once an FIR is filed, then case will, until it finishes in Supreme Court, it is a case. So what happened is when you go there and they will not file an FIR. So what are the options before us? So generally, what law prescribes is if a local station house officer do not file an FIR based upon your written complaint, you have to give the complaint to the send the complaint copy of the complaint to the district superintendent of police. It's like district head of the police. I have to send it to him and to a registered post. Why it is a registered post with acknowledgement? The next step is even with the superintendent of police do not file an FIR, instruct the lower police, then the option is going to the court. Where you go? The lowest court, the magistrate court. Then magistrate, the first thing he'll decide, he wanted to find out whether you actually went to the court, went to the police station. So to determine that, he'll ask, did you send it to registered post? Then you have to say, yes, I sent it to the registered post. See this copy of the receipt, and that is how it goes on. So for that, it is your burden. So this is the process, and the magistrate, after looking at your petition, will direct the police to file an FIR. This is a practical step like any other people does, and that is what I also do. But another important thing you have to learn is, if it is a serious thing, if someone is going to come and to break open your house and there is a rioting happen, and you can't go to the police station, or even if you went to the police station, the police is not responding in your favor, but you can't wait to send a letter and wait for 2 weeks. Before that, everything will be over. In such cases, you can always call the senior police officer. We don't have time. Another day, I will, if time permits, we'll talk more. There are several, it is a hierarchy. Like in the military, you will start with the lieutenant, second lieutenant, captain, major, like that. Even in the police department, it starts with, in some states, starts with assistant sub inspector. In some states, they don't have assistant sub inspector, then inspector. These are the people who actually do the investigation, the lower level work. Then after that, these are the like then above that, the district will be headed by the district superintendent of police. Usually he will be an IPS officer. Sometimes it is not. And each district will be divided into 1 or 2 subdivision, police subdivision, and they will be headed by deputy superintendent of police. Sometimes it is an IPS officer, or sometimes police from state cadre. These people are not investigators, except for some category of offenses like um, scheduled atrocities against scheduled caste and scheduled tribe. Only for that, some police officers or deputy superintendent of police are designated for that. Otherwise, they are not. Then above that, like generally everything buck stops for public buck stops with district superintendent of police. But if it's a major issue, you can church issue or something, you can always escalate to the senior level. Like above him, there is a deputy inspector general, then inspector general, and the DGP, and goes on. So that is a hierarchy. So this is the place where, as a public, you interact with the police. But in the process, after giving a complaint, your role is not finished. If police calls you and your friends or neighbors to give a statement, the police, what you saw and what you about the details of crime, you should go and you have to tell them, and they will write it down and they make a statement. The statement which you made before the police need not be signed. Sometimes the policeman ask you to sign, but in the court, without your signature, they can file the statement. The statement do not have much value in the court other than to contradict your statement which you gave before the judge. Then the second instance in a criminal case you have to interact is when the trial is going on. you will be called to come to the court to testify in the court, like 1 or 2 days. You have to come and tell what happened, what you see, when did you went out, when did you came to the home, at what time you saw that the door is open, and what you saw actually. Then after that, what you did, you gave a complaint. All these things will be shared in the court, and opposite counsel will process them. Sometimes there is a notion that, oh, if you give a complaint every time, every day you have to go to the court. That is not true. In a criminal case, once or twice police will call you for giving statement. In the criminal court, your role is as a witness to give a testimony. Might be ideally the day you come, the court should conduct a examine you. Sometimes if judges on leave, it is adjourned, or if you are there, you are supposed to. Like ideally, 1 or 2 hearing, everything will be over. But the here's the story is no. If you file a case every day, every day there is no need to go to court. So with that, as a public, what your interaction with the criminal justice system, I mentioned it. But at the same time, if you think one of your daughter or a sister who are married off to someone and he's very abusive, and one day you come to know that he or she was killed or she was died, then you suspect that it is a murder, then you can wait for, you can go to the police station and give a complaint. If police do not do anything and the husband side is trying to cremate the body, then the option is either through a lawyer in the High Court immediately asking for a direction to stop that funeral and ask for a postmortem. So like that, there is an option is there. At the same time, even after filing a FIR, and if police did a postmortem, then finally the police charged this husband for murder. When the case is going on, you still can, through a private lawyer, can follow up the case. So it is not like, but you can't participate, you can't conduct the case, because when it comes to the crime, it is the police to the state. State means the government of a particular state is in charge of dealing with the crime, and it will be done by the police. So victim have a limited role. So this is about the criminal process. When it comes to civil procedure, police is not involved. When it comes to offense, like a penal offense only, it goes to criminal law. Otherwise, it is a private. Civil is like a private offense between husband and wife, between you and your brother. There is no police involved in this matter. So here, even in the civil code, generally the lowest trial court is municipal court, then it is a sub court, then a district court, then High Court and Supreme Court are appellate court. Then there are some specialized courts are there. I think there is no need to talk now, but I just give a hint. For example, if you are a central government employee, if there is an issue related to your employment, then there is a tribunal called Central Administrative Tribunal. And if you are in armed forces, and if you have some problem with your promotion, employment, and there is a tribunal for armed forces tribunal. And if you have an income tax issue and there is a problem assessment, there is a models are passed against you, then there is a tribunal for that, special courts for that. Or if it is an issue related to environmental problem, then there is a green tribunal are there. These was also are court, but very specialized court. Only they take up the matter. But otherwise, our family court is a separate. But otherwise, all the cases, civil matters will come before the civil court. Civil court, the thing is, as I mentioned earlier, in a criminal court, the entry point is magistrate court. From the magistrate, you will decide where the case will be. Here, you will decide which court you will file based upon the nature and the value, the location, the jurisdiction. For example, for a matter in Chennai, happened in Chennai, I can't file a case in Goa, the place location. Then the value of the property. For example, if the value of the property is 1 crore, like or above, I can go directly file a case in High Court. And if the value is less than 1 crore, I think 1 crore or 10 crore, there is a monetary jurisdiction. If it is 50 lakhs or like 50,000 or 1 lakh, then the lowest municipal court can conduct. So you can go directly to the court. There is no entry point and everything. Here, there I mentioned that in the criminal code, prosecutor and accused. Here you say that in a civil suit, plaintiff, if you give a complaint, you will be called plaintiff, and other side is called defendant. And sometimes it is not suit. The name of the petition you file is called petition. And if you file a petition, then other side is called respondent. So this is the terminology they use it. So in a civil suit, how it starts is, if you have a dispute with your neighbor, or if you have a problem with your family, husband and wife, usually you go to a lawyer, and you should go to the lawyer. Then, like after a negotiation and everything, then you should go to the lawyer. The lawyer depends upon the nature of the case, will send a notice. The question is, whether in every case the lawyer have to send a notice? Not necessary, because usually you will when you go to the lawyer will say that let us issue a notice and kind of thing. But we should be very careful. Unless law requires that you should give a notice, issue not issue notice. You can go straight to the court. But there are cases where law requires you should give a notice. And again, after if you are on the other side, you receive a lawyer notice, whether you need to give a reply to that, not necessary, unless your lawyer thinks so. Is why it is I'm saying that is, sometimes other guy will not have a case, will not have any evidence. So when he send a lawyer notice, in your reply, if you admit certain things, then that will go against you. That is why it is very careful. Like you automatically should not send a response. You have to be very careful. Then finally, after this process, you will file a suit in the court, or petition in the court. For that, you need to pay fees. Court fees in the criminal in the civil court is very high. For example, in Chennai or in Tamil Nadu, it is 3% of the property value plus other charges. For example, if an apartment in Chennai costs 1 crore rupees, then you have to pay a court fees of 3%. That means 3 lakh rupees. Unless you pay 3 lakh rupees in the court, they will not take up the matter. So that was the biggest barrier for that. So what will happen to the poor? Poor, there is a process. Then you have to apply to the local revenue department, saying that I don't have a. You have to file a petition, then and in that they'll add the local revenue. The local revenue department have to make an assessment that this guy do not have money, so he is entitled for exemption in stamp, court fees stamp. So that is the process. So once you file the petition, the judge will look at it, and if you think that it is a good case, he'll assign a number and ask you to send an official notice to the other side. Then you will send the. Then after that, the respondent or the defendant come to the court. Then the court, after receiving within 30 days, you have to give a reply. That reply, there are different terminologies are used. Sometimes they call as counter, or they will say that written statement. So after this two processes over, then the judge will look at two documents: your complaint and the opposite party's written statement. Then he look at it, and he will find out what are the points of contention, what are points of dispute. Something like both people will agree. For example, like if you employ someone to do painting in a house, and that guy overcharged the amount, but as per your understanding, you agreed only 1 lakh rupees. Now that guy is coming with a bill of 6 lakh rupees. So when you come to the point whether he can come to your house to paint, if you agree with that in your counter, then that will not be a question. The point then will come down to that is whether it is 1 lakh or 5 lakh. So the point of determination, or the issues which the court is going to be determining, is called framing of issues. Then after that, then as I mentioned, the trial will start. That because you are the plaintiff, you are the one who, then you have to present all the evidence to address that issue, saying that why you say it is 1 lakh rupees, and other guy have to prove why it is not and it is 5 lakh rupees. I will present my evidence through documents and emails and everything, and he will also present through emails and everything. Finally, judge making a judgment. The problem again with the unlike criminal court, the problem with the civil court is even if you get an order from the court, apart from going for an appeal and everything, like if you are not happy, you'll go for appeal. If he's not happy, he'll go for an appeal. Then there is a process called special second appeal. If you're not happy, likewise you can go appeal. But even after finally you go to Supreme Court, finally you get an order in favor of you, saying that yes, it is one, or you get a favorable order or something like that. Or in a case where you file a suit, say that that guy have to give me 5 lakh rupees or 1 crore rupees because he borrowed money from me, 1 crore rupees, and it was contested. And finally, the Supreme Court says that yes, he's correct. Like you are supposed to give him 1 lakh rupees. With that case will not be over. Then there is another process called, again you have to go to the lower court, or there is a court called execution court or execution bench. Then I have to say that the Supreme Court said that he's supposed to give me 1 lakh rupees, and he's not giving that 1 lakh rupees. So please attach his salary and attach his property and action it and sell it and give that to me. That time that guy will say that I don't have any property, I don't have anything, and whatever I have is I don't have anything. Then what will happen? Nothing will happen. Maximum, but if he intentionally do not give, then you can send him to prison. But again, it is called civil prison. For every day, for his stay in the jail, you have to pay for it. So that is a sad part of the civil code. Then there is another thing is called writ jurisdiction. For example, if any violation happens, fundamental right violation happens, because in the constitution there is a chapter called fundamental right. You can go against the government in the high court by way of writ of habeas corpus or mandamus or anything. Like, but the idea behind the writ is the opposite party will be always the state law. Against the individual or a company, you cannot go. For example, uh, for example, the recent case I did is one of our friend who was selected as a like who cleared the first round of exam for the selection of judge. The second, before he take up the second round of exam, he was denied his admission, saying that you did not give proper documentation, so we can't admit you for the second level of writing examination. So the option before me is not filing a civil suit, because it takes a year. So I went to the High Court by way of writ of mandamus, asking the court to direct the State Public Service Commission to permit him to file to permit him to take up the second level of examination, because the error which they mentioned in the website is not correct based upon all the evidence. So for that you invoke this, you can go directly. So likewise, for certain cases, you can go directly to the High Court also. So these are the overview of all the law and legal system, and as an ordinary people, how you engage with the system. So with this, I'm winding. Like with this, I'm stopping my session. But if you have any question, now we have 10 more minutes. You can ask. Hello. If you have any questions, you can ask me.
Sir, can you hear me?
Yes.
Yeah. So you said that the reply has to be given within 20 days, something?
Not 20 days. Not reply. Like if when a suit is filed in the court, not like a
Yes.
lawyer notice. Don't worry about that. You can simply ignore. If if someone files a plaint in the court and the court admit
Yeah.
it by giving a number, and then court ordered notice to the other side, the other side after receiving from the date of service within 30 days they have to file a reply, that is called return statement. That is in a civil suit, but generally they will not do. They will find some excuses why they are not able to do, and they find some reason, but technically they have to file within 30 days.
Okay. So if you fail to file the reply, supposing now you are saying 30 days, do the defendant lose the right of giving a reply later on?
Not really. That is, it depends upon the facts and circumstances. Sometimes people file after 1 year.
Can you hear me?
Uh, it depends upon the facts and circumstance of each case. And if a defendant can give a valid reason, sufficient reason why he was prevented by giving filing within 30 days, then court will admit. You can't file after 5 years or so. For example, in one of my case, I was not able to file, like after receiving a notice, I was not able to file
Yes.
for a year or so because of the
Thank you.
COVID.
Yeah.
And the parties are in US and they are not able to collect all the required documents for me to file. For such case, the court will give exemption.
Okay.
What will happen? What will happen if you're going to the court at that time, I court, and there were others like also pending? Like there were so many people will be coming, right?
For what? Give an
Like no,
example.
we like if we are going to the high court, like if our fundamental right or something is violated, we are going to the high court. But there will be so many other people out there. So that time, like, will we have to wait like till a chance is given for us?
I think one of the important thing you go to high court is the principle. They say that you exhaust all other remedies or show me the emergency. Then only you can file it and you can convince the court. Convince the court. So it depends upon the volume of the court. There will be so many cases are there. But at the same time, you also should have an opportunity.
And usually, how long does it take for any case to come to a conclusion?
It depends upon the nature of things and how the other party cooperate and all this.
Okay, sir. Yes, sir. Thank you.
Hello, sir.
Yeah.
In case of inventory proceedings, within how much time would it take, like for inventory proceedings?
Inventory proceedings means what? Please explain.
For property?
Property. Property, it depends upon the. I think civil suit will take a long time. If both parties are cooperating, then within a year you can. It depends upon the docket size also, the court also. Year you can finish off. But the other party is intently with an intention to delay. He files a repeated petitions, rejection of claim. So many ways to delay it in civil matters. Then it goes for years. So my suggestion when it comes to property matters is uh, don't lose the possession of the property, because you do not know when the case is going to be over, like 10 years or 20 years, or sometimes within 1 year or 2 year or 3 years. So make sure you don't give away your possession. Let the court decide the final. Until that, you hold on the property.
Yes. Thank
Okay.
you.
So when it comes to, so even if it is a vacant land, don't allow that people to someone to come in. You file a case, ask for example, if you think that it is your property and someone is going to encroach that, immediately go to the police station and give a complaint saying that this is my property, don't allow him to enter. Then you go to the file a case for an injunction in the court saying that this belongs to this is my property. This is I am enjoying that. Look at my tax papers. This is the land tax I pay. This is the water tax I pay. I am in possession of it. This guy is coming in. Until the case is over, don't allow him to in. Ask for injunction or stay, something like that. So don't lose the
Yes,
possession. But if you lose the possession, even if you have all right, the other guy will be enjoying the property. So he'll try to delay as much as possible for another 10, 20 years if he have the money and everything. So after 25 years, what will happen? You will not be in a position to contest the case. Your children might not be interested, and finally he'll take off. So don't give away in civil matters. You see, civil matters. I tell to several matters. One thing is, if you're going to buy a property, don't be in a hurry, please. Some people say that it is dead cheap. If you there are so many buyers are waiting. If you are not going to sign this agreement for sale right now, and if you don't give me 10 lakh rupees right now, you are going to lose a good deal. Please don't fall for that, because if some is, I would say, if the price is 10 lakh more worth waiting and paying than going to the court for years. The reason is, you unless the uh, title which property you are going to buy have a proper title, or proper ownership is there, proper possession is there, and there is no dispute, there is no charges in the property, because sometimes people will mortgage the land with some bank or with some individual. So there are so much issues, or sometimes the property will be notified by the government for acquisition for railways or road or anything. So unless you make a huge due diligence, and there will be, like if it is a inherited property, there will be some other what people also who is going to make a claim on it. So make a due diligence before buying it. But buying it, then then you pay, even if it is more, pay and take possession of it. Otherwise, you don't go for it because just because it is cheap, then you have to run around in the court.
Excuse me,
sir,
sir.
could you? Hello.
Yeah.
Hello, sir. About this anti-conversion bill, could you explain us something about it?
The thing is, even though Constitution says that the minorities have a right to practice and propagate, uh, the different judges on the High Court and Supreme Court have their own interpretation. They say that yeah, you have a right to propagate, but not to convert. So that was the stand of each High Court, and everyone said that no, you can't forcefully convert people, and we also don't forcefully convert people. The definition which they say that the you forcefully convert people is wide and broad, so that any lower level police officer or anyone can file a false case against you. The problem with this criminal justice system is, uh, even they say that why you are afraid of this anti-conversion bill, is we are only saying that if you're forcefully converting some people to Christianity, or if you allure by giving some benefits, that is why that is the thing which we are against it. If someone wanted to go willfully, we are fine with that. That is the argument. But what we fear for the Christian people is, where the right wing people are so solid and vocal, they start misusing this law And if the police officer and the state which is ruling are also right wing side, the innocent people will be against FIR will be filed and they will be sent to jail. And sometimes if it is for bad luck, they will be sentenced for 10 years. They don't have. So that is the fear. So that was the problem. Otherwise, people should theoretically people will say that why you are fearing? If you are not converting people, then why you are fearing? And judges sometimes they say, "Yeah, you can propagate, but you can't forcefully convert people. That is their own choice." So that these are my comments on it.
Hello, sir.
Yeah.
If a person owes me some money
Yeah.
and he says that he doesn't have anything to pay me back,
He?
he doesn't have money to pay me back,
Hmm.
and then he goes absconding,
Hmm.
what can be done?
Practically, I will say that my experience. If you are not careful with your money, or if you steal someone's money, you are happy. But if you lose the money, rarely you'll get a chance to get it back. The cost of getting back the money is very difficult. As a matter of practice, what you can do is you can give a police complaint,
Okay.
and if you have complaint for cheating and
Hmm.
cheating, if it is something like that, after getting money, say that I will give within 10 days or so. If you don't give, and it is cheating or something like that. So there are some similar offenses. You will file an FIR, and the police can arrest him, search and arrest him. Then police can interrogate him, and if for cheating he can be put to jail or arrest him in the jail. Then there are ways to get it, but it all depends upon the police and the police how they cooperate with the cheating.
But the person is absconding. Where to trace him? How to trace him?
That police will find out.
Action. Thank you, sir.
All right. I think no more questions. Sorry, I just suddenly appeared into this class. I had already attended Richard's class for some time, and then we also conducted one full course for the pastors. It was very interesting and it was very helpful. And today also in his class I attended to, and many of the things he told us must have opened our eyes. But since some of us who are attending this class are new, even new to the entire subject of law, we don't have any experience. The field of law is a field of experience. Theoretically, if you study something, only less can be gathered. That's the reason many people don't go into it unless they have any problem. But when you have some problem, then all the information what he gave today are very, very helpful, particularly the basics. So when you have a problem, all that you know is there is a court, there is a lawyer, there is judge, there is police station, but you don't know how to initiate and how to go about it. But some people are who all are experienced are well experienced, and then they know all. But for people who do not know anything, should also have some idea about all these things. That way, it was very nice. So thank you, Advocate Richard, sir. God bless you. And I'm glad that you explained it very well, both in the morning and also in the evening. I'm sure many of us enjoyed it. And I somehow felt, after this class, probably I have to listen to it again, maybe once or twice. And some basic notes I should keep about the legal systems. Few things he was very, very clear. Even without any experience, you can keep those things in mind as to why constitution, what is the law, and what is police station, and what are different levels, and what are the different sections of court. Criminal is another one field, and civil is another field. and cost-wise. So it looks like, it is a very, very broad and then big institution. Systems and procedures are very broad. But however, it gives us a confidence that definitely we can use all these systems at some point. And we must understand how these systems are very helpful to us. So that way, I think it was enlightening to me, and it must have been enlightening to you also. So thank you so much. I think George is not there. So maybe we can finish here. And yes, anybody says something?
Yeah, one closing comment.
Yeah.
Usually when people go to a lawyer is when they have a problem. And I would advise that before engaging in the apart from criminal matters, when property matters or some major financial matters or something, please go to lawyer first, even though it is little money consuming first, and take the advice, then you go for like a registration or buying property or something like that. Because the big major companies will have in-house lawyers to advise them so that they will not run into loss. The practice of going to the lawyer prior to getting into a problem is not common in India. But in other country, before doing anything, they will try to consult the local lawyers there. If possible, and if you have money, if you want to avoid certain problems in future, the consultation with the lawyer before making any big transaction is advisable, not after run into problem. Thank you.
You're mute. You're mute. You're on mute.
All right. From my side, I want to thank Advocate Richard, and then hope George will get more people also on the other expert sites, the professional sites also. So thank you so much, George. Thank you so much, Richard. Yeah, George, I think time for you to close.
Okay, God bless you all. We will see again in the next class tomorrow. God bless you. Good night.
God bless you. Good night. Thank you.
Thank you.
Yes.
Good night, sir.